So time period for raising industrial dispute before the conciliation officer, again from 2 years, from 3 years, it is reduced to 2 years. Then factories, mines and plantations, yes, for retrenching, layoff or for closure, I think instead of 100 threshold limit for getting the permission for the appropriate government, it is now increased to 300. And as I said, only tribunal has the power to entertain any suit in relation to dispute concerning the trade unions and the members, right? So no other machinery will be available like court of inquiry or labor court or board of conciliation. It will not be there. The employer shall contribute an amount equivalent to 15 days wages. I think we discussed on this for every retrenched worker towards the workers reskilling fund. So apart from the compensation which is paid to the individual retrenched worker concerned, I think 15 days wages is to be paid, and this is to be deposited with the authority to be prescribed. It is more for the purpose of reskilling the workers. And with respect to standing orders, yes, we discussed on this. Again, the standing orders currently Act will be applicable if there are 100 or more workers engaged in that industrial establishment. That 100 is now getting increased to 300. And the central government shall draft model standing orders. So interestingly, now I think not only central government and other state governments, they also have model standing orders. But now I think it is very clearly saying the code. I think the draft model standing orders will be available only with central government. And of course, if some establishments want to adopt that, they can do so. They can make it as a set of laws for themselves by maybe adopting it properly and making it and submitting it to the authority and making it law for themselves. And the central government would be the appropriate government for telecommunication, insurance, and banking companies. I think we saw that under Code on Social Security also. This is there, and I think it is slight change, right? Certifying officer to look into the fairness or reasonableness. So in case if the draft standing orders are submitted to the certifying officer, then I think he has to look into the fairness or reasonableness, and he has to respond within 60 days, right? If there is no response within a period of 60 days, if he is silent, then I think it is deemed to have been approved. And standing orders already certified, that will continue to apply to an establishment. So, but if any particular clause is inconsistent with the provisions of the code, then I think that may not be enforceable. And employers shall consult the trade unions or negotiating union or council before submitting the draft standing orders to the certifying officer. So before again the employer submitting it to the certifying officer, I think they may have to consult the sole trade union available or the negotiating union or the negotiating council. Only then they have to submit it for approval with the authority concerned. Now with specific respect to trade unions, right? Again, special provision introduced for recognition, right? If there is a sole trade union, I think then that should be considered as a negotiating union. But in case if there are multiple trade unions, but if any one trade union has the support of 51% of the workers or more than that, then that will be considered as negotiating union. That union will be recognized. But in case if there are multiple unions, but no union has the support of more than 50% of the workers, then I think the employer has to initiate to form a negotiating council, maybe at the ratio of one representative for every 20% of the workers. Right. So anyway, there will be a body that can be a sole trade union, or it can be a negotiating union, or it can be a negotiating council. So there will be some body available in an establishment for doing the negotiations with the management's concern. And only 1/3 of the total number of office bearers of the union or 5 office bearers, whichever is lower, can be from outside the industry. Again, that is the point there. Then certain common points with respect to these 3 legislations: trade union, industrial disputes, and the standing orders. So the code empowers the appropriate government to appoint officers for holding inquiry and impose penalty in certain contraventions punishable with fine up to 50. I think we saw it under industrial relations. It is there. And the central government would be the appropriate government for metro railways, right? There is a confusion, right? There are conflicting judgments by various high courts. I think Tamil Nadu, Madras High Court, Karnataka High Court, Delhi High Court have given judgment on this. One court says it is central government, another court says it is state government. So there is a confusion that is getting settled now, right? Which means for metro railways, it will be central government, which is the appropriate government. And the central government will be the appropriate government for the establishment of contractors serving to the establishment, undertakings, etc. of the central government, right? Again, this is another interesting point. So if the contractor himself is a legal entity and if he is providing service to some establishment or undertaking belonging to the central government, then I think the appropriate government for them also would be central government. To provide penalty for different types of violations commensurate with gravity, we discussed almost whatever is available for all the other three codes. The same thing here also. There is an increase in penalty in case of violation of provisions of the code, and the provision for compounding of offense. We discussed on this. It is also there under this code.